I'm gonna have to get somebody in as well.
Next one to my Article 17. I gotta see if I can get back the numbers. 1118. Bernard, do I need a court? It's probably
I'm still learning guys. I left my class. I'm not making faces. I just realized, so that
So it's shown here and here, Bernard went to today, that's the hall, just so you can get it to show there.
it's pretty smooth, man. I got you.
Which Sylvia?
Can you run this for us?
What do you need?
There's not a snow cone stand.
So Joe's gonna fill that void.
I just want to go somewhere really. When Ellie gets home.
She gonna be working regardless. I pay my kids $5 an hour for it.
But I think that
Merchandising, new solar fences, we've been doing that.
for a kid in high school, that doesn't sound like a lot.
But yeah, you added, you got subsidized.
It's like living in the
But it's
districts, right?
like, yeah,
That's right.
benefit heavy over. Lots of solar fences. Well, let's get one here in my life.
Practice.
I have a flavor for you.
This is happening. For example.
I already have a flavor for you. Natural. Okay, I think we're set. You're ready? I think we're set.
How are you feeling?
Good.
You almost got bugged.
I would say that was pretty mild. Excellent.
First time it happened?
That's my second. I'm following the same as you guys, but yeah. Well, it's why I don't go and check out house. We appreciate it. Yeah.
I know, Jesus.
Yeah, Jimmy has
Yeah. I did. I just said like, oh God.
Okay, we're gonna start.
Are we, I guess the microphones are through, so you can hear okay? Yeah. And I'm gonna just speak as loud as I can through my mask. All right, well, good morning, everybody. It's really good to be back before y'all. I know it had been a minute last time, but it's been a longer minute for me. So I know that y'all wanted for us to go over some specific articles. Last go around, specifically 17, 18, and 20. Is that accurate, Ron?
Yes.
Okay. So we're happy to do that, and I guess we can start now, or did you want to?
Yeah, let me just preface it.
Sure.
Wait for me. When the city laid out these proposals, we just laid it out, but we didn't take the time to asked the city to bring these issues back so we can walk through, get an understanding of what it is the city wishes to accomplish, and then, we'll try to fashion a response after we have a clearer understanding. Some of them are evident on the face, but we're in a public hearing. I just want to say a couple things. Having dealt with this now for the last couple of years in bargaining, this is probably the most misunderstood and mischaracterized issue in police contracts. And I think that what we want to probably make clear is that Article 17, which is titled Protected Rights of Officers, is about the administrative investigation of an officer for violation of the rules and regulations of the department. This is an administrative investigation, and in prior bargaining in other cities, there tended to be people in the media mischaracterizing it, mixing criminal investigations with administrative investigations. We have no power in bargaining to change the criminal law or to change people's rights, either officers or citizens, under the U.S. Constitution or the state constitution. None of this applies to a criminal investigation. That investigation is handled by the department through their criminal investigation, and whether it goes to the federal or state or anyone else, they have their own path. And police officers stand identical to the public when it comes to a criminal investigation. So if a member of the public or an officer is accused of a criminal act, the officer can stand on their Fifth Amendment rights. They're not required, nor is any citizen, to give a statement. They can if they wish. So this kind of gets blended over, and you see public statements about, well, if I was charged with a crime, I didn't get 48 hours, or I didn't have 180 days, or I didn't have this and I have that. No, of course you didn't, because you're not an employee of the Austin Police Department. You're a citizen and you're accused of crime. You have all your rights established in the statute, state, federal, and the Constitution. So when we talk about protected rights, these are compelled statements against self-interest. A police officer, for an administrative rule violation, is compelled to answer the questions under penalty of being terminated for insubordination, or if given a false statement that can be charged with a crime. That has happened here in another city. So when we have this mix of a critical incident, there is a criminal investigation, but that has nothing to do with the union contract. And the officer operates as any citizen under the rights in the Constitution for criminal activity. You can't be compelled to testify against yourself. So now we have this section, which sets out what happens and what rights do the officers have when they're going to be ordered to give a statement against self-interest. And while there may be guarantee warnings, which says that if we compel you to do it, we won't be able to use this in a criminal case, it doesn't preclude it from being used in a civil case. And so once you give that statement is in the record. So I just want to say that let's don't mix up the two. So what we're now talking about is from minor offenses, rule violations, to serious offenses. But these offenses are all within whether or not the officer violated a rule or regulation, and the chief is empowered to investigate that, compel compliance by the officer, and then the chief can make whatever decision the chief wishes as to what they'll discipline the officer or not discipline the officer. And then we get to 18, we'll talk about if you are disciplined, what are your rights to have a due process hearing? Because employees who have protections under the law or a contract have a property right in their employment. And when an employee has a property right in their employment, as Austin Police do, they have certain rights to a due process hearing, and we'll get to that in 18. So anyway, I just wanted to make it clear, and I guess I can say whatever you wish, but I would ask that we just start to it, and I will ask you some questions. I'm going to interrogate you. I'll just ask you some questions, trying to get a grip on why the city felt that these particular provisions needed changing now. Many of them go back and are copied out of 143. Many of the things the city is changing have been in the state law for 25 or 30 years, and there's been no change there. So we just want to understand, what is the motive? What is it you hope to achieve? And what's not working in the language that exists today? And so that's kind of where I want to go. If you're willing to do that, then we can just start walking through it. And
Yeah, sure. Yeah, and I guess if there was some confusion about mixing the criminal and the policy, that certainly wasn't the intent. Obviously, we know that criminal is completely separate and apart. However, there is some overlap in deadlines when there's the backdrop of the criminal element with the policy violations. You know, if you're looking at 143 specifically, you know, go into the AG if we're going to go past the 180-day deadline, things like that, right? So there's a little bit of an impact that a criminal case might have on the chief's ability to discipline for policy violations, but it's certainly not our intent to confuse the two or merge them in any way. We understand what you're saying in regards to the policy. Right?
yeah, and I'm speaking broader. I'm not, you know,
Right.
but I think that when we say there's some issues that overlap, they're only overlapping on when he can discipline, not if he can discipline. Because certainly if there's a criminal case being investigated, that has to take priority. Because if the officer is found to have violated the law, then there's not going to be, there's not going to be a hearing. You're going to lose your license and you won't be in.
Depending on the charge.
Yeah.
Right,
So
right.
there are some issues of where they're parallel running cases. What the chief may have to delay or seeks to delay under the statute, saying, I need to continue this past any rules because we have a criminal case. So some of the I'm just saying, I think, just for more general statements, not
Yeah.
you personally.
No, I know that, and to that end, I guess if we'll kind of go over our intent generally, and if there's some tweaking that we can do, and if whatever we can provide, that'll maybe tailor a counter proposal for us. I mean, obviously we will take that into consideration. In regards to some of the changes in Article 17 and the definitions that have been added in Article 17, those were straight out of Article 16. So Article 16, as you know, we had proposed to delete Article 16 entirely. And then we took provisions from Article 16 and I guess salvaged them and put them into 17. So kind of just going through 17, definitions, anonymous complaint, complainant, that all comes from Article 16. Striking complaint and complainant in the current Article 17 is because it makes reference to Article 16.
I'm gonna just, I'm gonna work with you as we kind of
Yeah.
do it, so otherwise you go and then I forget what you said.
Yeah, no, interrupt along the way.
Much older than me. We understand in Section 2 that the city wanted to take some definitions from 16 and move along. Okay. We haven't taken a position on the city's proposal to remove 16. We have subgroup inside of our team that's been working on that, and we have every intent when we get to July meeting to put that and lay out what we think our position will be, whether we agree to remove it or whether we issue amended language. We'll do that pretty soon. We just haven't completed it. We wanted to get some other issues, wages and promotions on the table so that the city would have time to work on it. So I understand section 2. All right. I guess.
Well, if you want to jump to specific questions, we can, or I wasn't sure, it kind of made, it seemed like you wanted us to go through the whole thing again. I certainly don't have to. I think the biggest takeaway from 17, or I guess 16, 17, and 18 is the city's proposal regarding the G file, right? And so and I will tell you that the overall concept there is mainly transparency. And so the deletions and we kind of felt like it was somewhat beneficial to both sides in that there's a whole section here, access to records by officers, section 4, which kind of had a 48-hour provision beforehand, etc. That kind of all goes by the wayside if, and the officer is entitled to it sooner or whenever they ask for it, in regards to that. So the whole, I guess, overall theme there is transparency, to the public, to y'all, to just transparency with the whole process there. And if you go to section 5, DRH, the dismissal review hearings, we definitely didn't want to get rid of that. Section A in section 5 there also comes from the part of the section 17 that we struck. So in terms of notice to the officer, we definitely want to continue that, whether it's a compelled guarantee statement, the DRH, those are all things that we wanted to provide to the officer. Here's the misconduct allegations, here are the policy violations, here's the time that you will have to prepare for the compelled statement. So we wanted to keep that. I think that's also just consistent with 614, Texas Government Code, or Local Government Code, that would apply to any law enforcement officer, whether they're civil service protected or not, whether they have 143 or not. Sure.
Is the striking of language in section 3 compelled testimony, is it just you're striking this because it's linked to 16?
We're striking this because it's linked to our proposal in removing the G file. Our real only intent there is not to take away any substantive due process notification rights to the officer. If you see something that you think it does, that's not our intent. It's just access to records by officers goes into 089G and that remaining confidential. So really, I'll be honest with you, when we were kind of going through this proposal, we were starting to kind of just only take out where it had reference to 089G. And then we realized, you know what, if this actually doesn't all apply, this doesn't apply at all. And the officer just has access to these records. So that's sort of our intent there.
Well, tell me, you struck a complete section, access to records by officers, and it really has to do with notice and the right to review certain documents prior to making a statement. Why did the city feel the need to strike all of that?
Well, we salvaged some of it and we put it in the bottom in regards to notice. And we also tried to read, and I'll be honest with you, I think we kind of overstruck on that section and we put it in, you'll see also some of that language exactly in Article 18 in regards to notice to officers and alleged misconduct. So I think if you look at struck provision D, current D, that's been, no, that's not correct. Basically, any provision in regards to notice to the officer before a compelled statement, that's what we tried to salvage, and you'll either see it lower down in Article 17 or in Article 18.
was it, if this language has been in the contract, and we're talking about a page and a half, and you struck all of that, and it's been, I guess you understand, you piecemeal parts of that into other sections. What was the, are all of these rights currently guaranteed, now gone? What rights
So,
did you
so
feel?
let me try to restate it, maybe
Go ahead,
it just
yeah.
wasn't clear. With the deletion of the G file, the officer already has access. This is unnecessary. So the parts that weren't covered by the deletion of the G file were salvaged and moved. So access to records by officers, you have it. Part one, you have it
Where did we have?
by deleting the G file. So our proposal to delete the G file is hand in hand with this. That's what we're saying. When you delete the G file, the officer then has access to the document.
Go ahead, go ahead.
So we don't really have access to that information because there's certain like evidence retention rules within the department. We have, preservation of the integrity of an investigation. I cannot just go onto Axon and start watching videos of mine that have been locked for investigative purposes. So we don't actually have access with the removal of the G file.
So our intent here is to be compliant with the G file. So like Becky's saying, if you see something that we're not giving you access to or that has been taken out of here and not moved, the intention here is to make it consistent with the removal of the G file so that you already have access to your personnel file. You may not have access to maybe an investigative file or something like that, and maybe we caught it, maybe we didn't. We hope we did. So if that's what you're not seeing, that's what we need to work together on to make sure. We're not trying to take that away from you. We were removing this for the purpose of being consistent with the removal of the G file. Because you already
not
have
to take away our right to review evidence prior to providing a compelled statement.
No, not at all. In
Okay,
fact,
so that
we're
needs to
trying
be
to remove the
addressed.
barriers, like the 48 hours, you would get it immediately because it's basically already.
Wait a minute, maybe I'm not, I'm not. I always am nervous when people strike massive amounts of existing language that we've lived under for decades. And then say, well, we just put this one sentence over here and it covers it. I'm not understanding. I understand you want public access to the G file, which is currently under the state statute as confidential. We can talk about that. But all the things that are in here, you can see it immediately. Well, but I think this is about having notice when you're subject of investigation to look at a copy of the complaint and see certain things prior to making a statement. Am I wrong about this?
So you're not wrong, and the goal is to not take that away by any means at all. And if we're taking out the G file, the whole point was to make it more accessible to y'all, and not. We kind of saw Section 4 as without Section 4, there were barriers to get that access, right? So the goal of removing Section 4 was to eliminate those barriers, right? But regardless, even if we didn't have 143 at all, we're still required to provide the officer a written statement with a signed complaint, just already under 614. And so we're not proposing to take that away by any means.
Yeah, but Rebecca, if the intent of the city is to roll this access back to 614, 614 is really for everyone out there who doesn't have civil service or a union contract. It is the bottom of a benefit the state gave to police officers, and it's almost unenforceable. So we don't want to go back and operate under statute that basically applies to at-will workers. So I don't understand. I understand you want to make the G file public. Okay, I understand. That's your position. But I don't understand where you think we get access to that we have under this page and a half of protections that we still have. Why not leave all this in there and then make your position that you want the G file open? I understand your argument.
Well, and we're not opposed to that. And really, when we looked at Section 4, we started to do just that, just kind of remove the sections to G file because that's our overall goal. But then we realized, you know what? Maybe since we're removing or requesting to remove the G file, well then this should all just be open up to the officers as well. So I see what you're saying, and we don't just, and I guess
And so,
don't
if I can
disagree.
tell you where that exact statement moved to, is Article 18, Section 19.
Right.
So Article 18, Sylvia, if you could go to Section 19 on Article 18. So we moved it, and maybe you disagree that it should remain under the heading of the protected rights of officers. We tried to retain the concept, and, you know, whether it's in the right place or not, we specifically tried to retain that. Is this the portion you're talking about?
No. Nothing in here has anything to do with the right to review prior to giving a statement.
And so what we tried to do is we tried to salvage part of this section 4, and you'll see it further down in 17, and what Sylvia just has on right now, which is Article 18, Section 19. If it's in the wrong place, or if you want to put back Section 4, we're open to that. The goal was not necessarily to take away due process rights in regards to notice to the officer or the officer's ability to review records before they provide protected statement.
Yeah, go ahead.
I think it's important. I would hope that you guys recognize kind of where our numbers are in terms of level of comfort with the internal affairs process as we have lived versus what we negotiated for over almost 2 years in 2017, 2018 to try to get to a system that we thought was moving forward. So our folks went out of contract, lost thousands and thousands of dollars of soft money, put their households under a tremendous amount of stress. We come to what we believe is compromise. Our membership very much felt like what we negotiated for and how things were being implemented were vastly different. We finally got to an arbitration where our members won. And so I try to think about these negotiations in terms of like the average cop that's an APA member that's going to have to ratify this thing. And I would hope that in y'all's quest to move this forward, that y'all also just remember that we're down to like 1,600 cops now, but like the ones that are still here and the ones that'll be here whenever we get to contract ratification to a vote, like those folks are going to have to be comfortable with whatever language it is that we're proposing.
And I appreciate that, and I understand that, and I said that really wasn't the overall goal, was to remove any sort of due process rights or notice to the officers, or take away any sort of comfort level that you already have with the IA process. And so we welcome your feedback. I think these questions are good because I think it focused, it kind of said our focus is really transparency with the G-file, not to disrupt the IA process.
And I think, and I don't remember the exact words you said, but you're like, hey, but they have that. And what we've seen a few times is we've been told, well, it's not written here, so therefore you don't have it. So a level of comfort for me as the vice president of the APA for our membership to say that, and this is nothing against anyone sitting at the table, but that we're going to take anyone's word that a certain process is going to be a certain way because of someone's word at the table is zero.
Right, and that's why we moved it to the other section. I will tell you, we were intending to reduce the time frame from 48 to 24, and you'll see that we just lost half of our screens, but anybody who's watching it can see it behind them still. You know, and maybe that should be right where we took the other stuff out instead of move to 18. You know, so that it can be clear what's still there. You know, maybe reorganization is a concept. We did give this to you in March, so you would have plenty of time to actually, you know, kind of meet over, because it is a huge change. We get that, but we're hoping that you can, you know, like Ron's questions are very specific as to things he's concerned may have been left out or may not have been included. And your point that your membership is going to be very skittish, we get, and we understand that. But we're here to talk about it. Any questions, any discomfort, we want to work through it. We think the transparency portion is huge. Both to your members being able to have access to their files immediately, But also
And I guess that's another thing. So the reality of the situation, like say we move out of having a G file, and I think it's easy for us at the table to say, hey, it's not a big deal, you'll have access. But I think to the point that Officer Garner was trying to make, if Lieutenant Askew's running an internal affairs investigation on me, right, or there's a criminal investigation in Lieutenant Streepy's office up in this building, like this idea that I'm going to be able to go in there and say, I want to see these things is not accurate. They're not going to compromise a criminal investigation or an internal investigation. But because I go ask for some documents, it's not going to happen.
so what in 17?
I'm not saying that currently that we have that right. I'm just
Yeah, that's
saying,
what I'm-
and I agree with, no, I'm just saying that the notion that we can say, hey, we're gonna eliminate G-file and it's great for everybody. I don't think it's that simple. I don't think it's simple enough to say, hey, we don't have to, we can get rid of all this language. This language is not necessary because you just have it as a nature of being. I don't think it's that.
Fair enough, and I guess if there's parts of section 4 that you would like to put back in, because we're not opposed to that, and, yeah.
All right, well, we are prepared to bargain in good faith over any issues covered by the scope of being confirmed. That's pretty broad, and we're gonna do that. But at the same time, this section was bargained ad nauseum just a couple of years ago. We made changes to create discovery at the level of assistant chief, because the city had complaints that it didn't get up to the chief. We worked on that. We had other discussions refining the 180-day rule to be inclusive of the below gauge language we accepted about if you don't have to be, and this may be inside baseball here, but basically to invoke discovery to charge an officer, and we'll come to the 180-day rule. It doesn't have to be that the officer committed a crime. It's only that the disciplinary rule is related to that. So you may never be charged. In Lowell, the city gave us language, and we accepted all of that. We made changes to the 180-day rule. We made changes to a whole bunch of things, including with trigger discovery. And now we're back a couple of years later, and you just look at it on the surface, it just guts out all the things we did and just rewrites them. So,
Well, if we did sit here and we negotiated that article ad nauseum, and we thought we had a meeting of the minds. But when you have 17 grievances over an article, and both parties disagree on the outcome of an arbitration, and all of the 17 grievances, clearly we did not have a meeting of the minds. So we're trying to come back in and make sure this time.
tell us about the 17 grievances, because I'm not aware of that. Are they all on the same topic?
They're on the OBO article. Is it not 17?
Okay, but we haven't, and I understand your position is to take it out of the contract, but we haven't responded on that. But as far as internal affairs investigations, I don't know that we've not had any. So when I look at this, then my question would be, tell me what is not working. Are there places that it's not working? Because we're not seeing that.
On internal affairs investigations, in conjunction with OPO, in conjunction with all of it, it's not just a matter of what's working and what's not working. It's all kind of a big, there's a connectivity, and everything isn't working jointly. We have a national outcry to be more transparent. We have a local outcry to be more transparent. We are trying to listen to that while being respectful of the officers' rights. We want to bargain with you. We're not trying to slam down a mandate to you. We're trying to work cooperatively with you. It's whether or not there's agreements on that section, whether there's not many agreements cases on the other, there's additional concerns regarding transparency that we want to work on with you. We know that you've also expressed that desire too, so we just want to try to get together and
Let's be clear, because we're slinging words around. You say, and I understand, you say, tell me what transparency has got to do with the 48-hour notice or the 180-day rule. I understand there's a lot of issues on the oversight side. People want it to go one way and others the other way. But inside of this art, someone makes a complaint against an Austin police officer, then if it doesn't involve anything that, has a criminal side, it goes to IAD. If it does, it goes two separate paths, and they don't interact. They both have their jobs to do, and the officer has to answer for whatever they're acting. Inside of this, compel statements against self-interest and being access to being able to see before you have to write your statement is pretty common in all these contracts. So when you use transparency, but you strike all the things that would have allowed the officer to see transparent on the city side, where is that? I don't understand what you mean by
So
this sister is transparent.
Yeah, so I think transparency is taken on a larger scope of the term, which includes kind of a general concept of I think the example that Devin had used is, if there's a complaint against Devin, everybody gets to see it. He doesn't get to see it 24 hours ahead of time. He doesn't get to see it 48 hours ahead of time. He's called into an office, just like every regular human being who has a job, and they're asked the questions right then and there. He doesn't get to study it ahead of time. So I think the shortening, the lessening of that sort of time frame, although I use the term transparency, I use it, kind of in the way it's being used now to mean a lot of things. It's not just transparency to see what's going on, for the public to be able to see what's going on, but to have a more equitable treatment. And indeed, it's a bargaining session. We're trying to bargain away some of the time frame because the general public doesn't get that, and there's a general sense of unfairness that we're hearing from the community.
But let's throw the word equitable around. I seriously doubt Devin's going to have to arrest anyone, wrestle him to the ground, be injured or killed, or have that person injured or killed, or face a compelled statement that might lead to a civil suit or criminal action, grand jury, federal, state. Devin will get fired because I didn't come to work on time, or his boss doesn't like his work, and actually he's a management employee, and I seriously doubt he has any rights. So we're talking about a person who, it's not just the job side of it, it's the implications that go with it. We didn't just start this today. I mean, in 1947, the legislature said we think police and fire ought to be protected from political interference and have due process rights and have property right in their employment. That goes to 1947. I think Austin came in at like 50-something. So for all of those years, we've had a fundamental right. And the state, almost every state, carves out those people who in their job face other things that could be a consequence of enforcing the law. Laws they didn't enact. They didn't pass them. Government says, you're our agent. Put your hands on that person. We want that person brought to jail. Now, there are rules for the officer, rules by law. So, Devin's not. So now, the public doesn't. Part of this goes back to our original deal. Whether I gave you 24 hours to report or 48 hours, a lot of that has more to do with when they can get you scheduled. Because unless it's maybe extremely high profile, well, this officer was rude to me. It could be a month before IED has time to look at it or even get you down there. So it's like, whoa, we're letting all this time escape. He goes anyway, because this is just the point at which they're prepared to take the officer's statement. If I'm wrong, we'll get an assistant chief. So at that moment, virtually all the unionized police in Texas and most of America, they have a time period to say, report on Wednesday at 9 o'clock, and we're going to order you to give a statement better be truthful, and if not, then, or you refuse, you will be terminated. So, that's all the time period is about. So, 48, 24, 6 months, it doesn't matter. You could have no time period, but still they gotta tell you to come down. They gotta have everything in order. They have to show up before they've even looked at all the evidence and have all the questions prepared. So that's one of those little triggers that's thrown out there. Now, people don't like the 48 hours. All it is notice to show up and testify against yourself. You can make a decision on that moment. And at that moment, the officer has to tell the truth. If they fail to do that, there are serious consequences. That's happened here throughout the country. So, I'm okay. You want to make that your proposal, but
And just, we're not proposing to take the notice away and all the requirements that are supposed to go into those complaints and work with the officer and their representative to reschedule that. I mean, that's all stuff that would.
I didn't see all of this put back into 2 paragraphs. I didn't see all of these things of which the officer now has notice and a right to see. He can see everything. There are things he has a right to see, of which IED has at that time. All of this is gone. Now, you say it's back, but then you have a sentence here or a paragraph. Well, I had a page and a half of rights that we bargained in many years ago. And we're prepared to discuss each and every one of them. But I would ask the city maybe go back and rethink what it is your objective. If your objective is, we think it ought to be 24 hours, then we'll have a discussion about what that time can be. If you want to discuss, and we'll come to the 180-day rule, we'll have a conversation about that. Those are fair discussions. But where our concern is just getting it back down so the protections prior to giving a compelled statement are gone from the contract, and they don't exist. You have a right to see your own body camera per state law.
Right.
There are no other rights for you other than get the statement of the complainant. But all the other things of which you brought them in and asked them to answer, those things aren't given out in any other state law. They're struck from the contract. They don't exist.
So we tried to put that back into 18. I know we're at 17 now,
I
but
didn't see all that back in 18.
well,
All of these things that you struck in 17, you tell me are back in 18?
no, I'm saying that what we tried to do is originally we went through section 4 and kind of piecemealed it to the overall, elimination of the G file, right? And then we, quite honestly, we thought it would be a benefit to you all to be like, okay, this kind of takes away some barriers. I'm hearing you now that it is actually causing more consternation than anything. That's not lost on us. And yes, we will go back and we'll take a closer look at it, but we also welcome, any proposed changes you want to put back in as well. Is kind of where we're at. I mean, we're not saying no at all.
I understand, but I think we'd ask the city to put the contract back where it was and then articulate things of which you feel that you need to have change. I understand. You want 16 out, 143G in, you want it to be 24, not 40. I understand all that. Before we start striking out rights and acting like they're somewhere else, that might have been your intent. That's not what I'm saying. And while I'm on it, let's talk about the 180-day rule. That's the other.
So we're skipping to 18.
Yeah, well, yeah, because I've already said on 17, I need to, that's it, that's the real key there, all the stuff that's struck. If you have something else on 17.
The only thing else that was on 17 is just how we were going to move forward, as this goes in line with the city's proposal on the G file and just to kind of go over it one more time again since it's been a minute.
I have a question on that.
Sure.
So, can you just
Scroll down a little bit.
explain to me, because I don't understand, what is it exactly that,
Section 6. I'm sorry.
that's okay. What is it exactly that you're trying to accomplish? What are you looking for in the G file?
what we're looking for is to remove the protections of the G file and just basically have the officer's file be treated like any other personnel employee in the city, or how any other officer in a county or a non-civil service. So they don't have G file protections in counties, and certain cities that don't have 143 don't have the G file provision. So our proposal is everything moving forward after the effective date of October 1st, 2021, or whenever this contract is ratified, everything that is created afterward that would be considered G file, that be basically considered like almost A file, right? And that everything that's created or maintained prior to October 1st, that would all stay the same. This is our crack at it, basically. We're happy to have that discussion, but that's
I guess I'm just confused as to what you think is in there.
well, the point is transparency, right? So when there is a pending investigation, policy-wise, whatever, that's all we're talking about. We're not talking about criminal. If there's a pending investigation, as Sarah said, in any other department, county, or non-civil service city, there's no G file protection, right? So it's just a step toward transparency. And I know the G file covers a bunch of different things, which include investigations that are either ongoing, right, or they're unsustained or unfounded or whatever. That would, an officer does not get disciplined, it remains in the G file. What we're saying is we would like for those things to be open to the public. And I can understand the consternation there and but as I said, this is something that is ongoing, has existed in county law enforcement agencies, other non-civil service cities in the state of Texas. Our position is the world will keep spinning and it'll be okay. But that's the goal. And so the overall goal, I guess the theme would be, as Sarah keeps saying, transparency, right? How we get there, we're willing to discuss tweaks here and there with the language. We really try not to have too much of an effect on the IA process in regards to 17, but that's sort of the overall.
Well, I mean, I think it's just also important to realize that there may be investigations in a G file that have absolutely zero merit. They were completely unfounded. And by virtue of the fact that anybody can make a complaint about anything, whether it's true or not, and that information is in there and could be totally disproven as wrong. But then once that becomes open, the headline is, well, this officer had this horrible investigation, whether good, bad, or otherwise. And so, I mean, the ability to cast aspersions on someone's good name without merit is, it's troubling. I would also say transparency, we need to flip that on the side of things that were occurring in the monitor's office as well. So we would love for everything to be 100% transparent. If you want connectivity, because they're all interconnected, removing the monitor from a contract removes connectivity altogether. So I would just sit with that for a minute as well.
Here on Article 17, Section 5. This is just a ladder mill hearing. And that basically is right. I assume everybody's got it there. They do in both sides. And that is, prior to being terminated, you have an opportunity to come in and speak with in this case, the chief. And you can make your case. It's not a hearing, it's a ladder mill hearing. It's not like an arbitration or some sort. What was the purpose of adding new language there that you felt didn't work now? I mean, what?
You talking about Section A?
Yeah.
That should have come from either 16 or higher up on 18, what we were trying to do is not take away this provision and the ability to see whatever it is y'all needed to see before you have that hearing with the chief. But we actually were trying to leave the DRH process as alone in a sense. And this is one of the language that was salvaged from from 16 and other parts of 17.
Okay. If we could, on Article 18, which is actually this one. I understand Section 6 about you want the G file to be a public file. We'll have a response at a later date. We understand your position. If you would go to, let's just go to the 180 days, the other element in the room. That's in Section 8.
Article 18.
Section 8, Article 18. This is one of a handful of things that get thrown out into the universe with very little understanding of what it means and what the intent of it is. By people who think, well, for some reason, people are getting away with things because of this rule. Basically, all the 180-day rule is the statute of limitation of which the department has to charge an officer with a rule violation. So, do it criminal, anything. So, Civil Service statute from 1947 to the mid-80s was 180 days from occurrence. There were no other exceptions, but the police associations, the police chiefs, and the league got together and said this has to have a broader definition. And I was involved with that in the mid-80s. And we changed the law to have a bifurcated system. So if it's just a rule violation, then the city has 180 days from occurrence. Okay. That's not in the Bible, it's in the statute. It's open to discussion. The second half of that was, if the offense of which the officer is accused is allegedly related to criminal activity, including any violation, then the city has 180 days from discovery. And this is language that the city gave us last time. The city must allege the act complained of it is related to criminal activity. The chief will not be required to prove criminal culpable mental state under this section, nor shall the chief be required to prove charges under a criminal beyond a reasonable doubt standard. So you have basically in the current contract the state statute with a little more definitive language that the city of Austin requested and we agreed to. We don't see any reason not to. So under the current state of the contract, and pretty similar to what's in the state law, it's just not as defined. If I were to, let's just say, I assaulted a citizen, but the city didn't hear about it, we went past 180 days, and then one day that citizen comes in 2 or 3 years from now and says, this officer assaulted me, then the department can open the investigation because they just discovered assault is a criminal activity. You don't have to, the officer may never be charged with assault. The department has the right to start that investigation 3 years, 5 years, 10 years, actually 25 years from now if they discover it. They have another 6 months. And they actually have the ability, under some provisions I was involved in. So if this investigation needs to go longer than that, they go to the Attorney General and submit notice, and they automatically continue the criminal investigation past the deadlines to to charge. So those things placed in the law 25 years ago or so, and 40 years ago. And today, we've expanded this to meet the request of the city. So I guess I need to know who's getting away with anything based on the statute of limitations.
So, to me, the way the current contract language reads, so I get what you're saying, like somebody comes in 3 years later, but I think that's pretty rare, right? And so the way, and I'm kind of coming from an outsider looking in, and I'm looking at this language, and what typically mostly happens, right, is an incident occurs, and that's the day we discover it, right? A shooting or something along those lines, right? And so then the Rangers investigate. Nobody's charged, right? So no one's charged at all. The Rangers are investigating, but the date of discovery also happens to be the date of the incident, right? And so if you look at this language, the current language, not what the city proposed, and I'll go into that in just a second, but the way it currently reads, if the act is allegedly related to criminal activity, including the violation of federal, state, or local law, which police officers are subject to a criminal penalty, the chief may not complain of an act that is discovered earlier than the 108th day preceding the date the chief suspends the police officer. So to me, it actually looks like it's putting a time limit to 180 days that is not currently in the statute under 143.
So you have to restate that.
Okay, the way it is read. So your situation, I understand, the date of discovery, right? That somebody comes in 3 years later, the chief has 180 days basically to discipline, right?
That's right.
The way that this is reading, and I know you're saying that the city has the ability to go to the AG if there's pending investigation for the sake of the integrity of the investigation, right? But that's not written in here. That's actually not written in here.
Go to
Is it your
B.
position
It
that-
is. Go to B.
Well, so
It says the chief may extend, this is not the statute, it's contract, may extend not to exceed 30 additional day increments.
the chief, the officer, and the chief may agree. And so 143 doesn't require.
Well, it means he'll just fire you,
Doesn't require.
okay?
Well, and that's kind of what we were trying to do with 2, right? So was to track 056 just a little bit more. It covers those outlier situations that you're talking about. Something happens 25 years down the road, that's the day of discovery. I think those situations are pretty rare. But what I don't want to cut off, and that's my intent, right? I'm not trying to actually take a step backward. The intent really was, I don't want to put a limitation on the chief's ability, because most of the time, we find out on the day that the incident actually occurs.
And he has 6 months to issue a disciplinary charge.
And
And if it's criminal, an officer's facing criminal, he can get even longer extended.
correct.
So the reason it's rare is because virtually nothing falls through the cracks.
And-
If it's a serious incident, other officers are there, citizens are there, video cameras are running. You have 6 months to terminate it or just.
Correct. And if we need to go beyond that, then we send the letter to the AG.
That's correct.
But then the chief is limited to an indefinite suspension or nothing, because that's what 056H says, right?
Then why don't you just look at what you need to fix in 143.056 instead of changing the whole dynamic?
Well, and I don't feel like we're changing the whole dynamic here. By increasing it to 360, then that also increases the chief's ability and the officer's ability to do somewhere in between nothing and indefinite suspension. And
But-
so,
365 from discovery for everything, non-serious offenses.
and I will say that the city's goal really lies with number 2 more than 1.
I'm sorry, Thomas.
I'm sorry, yeah.
It's like I'm used to it. I hear what you're saying, and I'm glad that you cut me off, because I understand better. And I guess I'll echo Ron's statement is, if that's truly a concern, right, that we've pressed the pause button to allow criminal investigation to take place on a critical incident or on a major use of force or something, right? And then now we're ready to hit play, and we have 30 days, and that's our only 2 options. I think our team would be open to having that conversation. I think it's an easier thing to explain to our membership than, hey, for these very, very, very rare occurrences, and And I'll say that we are lucky in this city that we don't have more deadly force situations than some of our sister cities across the nation, right? They're all tragic when they do happen. They're incredibly stressful on our officers. They're obviously incredibly tragic for families of community members that are involved. But when they do happen, that's something that we feel like we need to work on. It's a much easier thing for us to explain to our membership than we have this very rare occurrence, and so to try to fix this issue over here, we're going to do these other things.
Yeah, and in our tweaking here in number 2 was really, I didn't want the exception to overtake the rule, and that's sort of how it currently reads, is that those rare exceptions that Ron, you just mentioned, somebody coming in 3 years later to complain about assault, that's pretty rare. What I didn't want is for that exception to overtake the rule that, honestly, probably most of the time, the incident occurs and the date of discovery are the exact same day. And so that's the only thing I was trying to not cut off our nose, spider face, or whatever. And I don't want to speak out of turn with the city, but there, in other, because this only covers those instances where you're in like that limbo period, where there's possible criminal conduct that's being investigated by the Rangers, but there's no charges, right? So when charges actually occur, a misdemeanor, higher level misdemeanor, or felony, you're talking about a whole other section of 143, right? And that's when the 30 days. So, and if the officer, whatever the final disposition is, whether there are no bills or whether the charges are dropped or whether they're found guilty by jury, that's when the 30-day clock starts for the chief to do something policy-wise, right? And so I have seen in other contracts where they've kind of taken that 30-day trigger, where let's say the Rangers are investigating, we go to the DA, there's no bill, and then the 30-day trigger starts that would otherwise have occurred when there was a charge. And I feel like I'm trying not to be confusing, but I think we're open to however we get there. But the whole point was, if you go to the AG and go past that 180 days, or the 360 days, whatever, 180 days, the chief's sort of limited to doing one of 2 things, indefinite or nothing. And I think it benefits both sides for the chief to be able to do somewhere in the middle.
And so we've actually, I can think of 2 cases that one case on the thing that you just explained, right? Like we didn't get the charges, and we worked through it with the city. But I can understand how addressing it in the contract would make it easier and cleaner for all parties involved. And then we have other cases on the 30 days after,
when charges are actually filed.
We had a couple officers that were found not guilty, and then had to kick off that time. So I'll just reiterate, much easier for us to sell that to our membership, to explain that to our membership, if we can.
We understand, and we're not, I think I can say, and most teams, we're not trying to use contractual protections for someone to avoid answering for their we look at the process, what's fair, and in the end, the officer has to answer for their conduct, whether it was intentional, unintentional, training failure, all of those are factors that you would weigh. So, if you would perhaps relook at what you have and focus on this period where there are parallel things going on, and the chief wants to preserve his options to discipline when one of these is concluded, then we do have some statutory stuff, but if that's not clear, then let's talk about what's clear. I think Tom's correct. We're not trying to do it. I don't think there ought to be any gotchas, and we don't think there are. I know people believe that there are, but I can't factually find them. So anyway, we understand, and let's see if we can come to some meeting of the mind about what you're intending.
Yeah, and I'm not accusing anyone of any gotchas. It's,
No, I mean on our end, we don't want the contract to be a gotcha.
I don't think any side does.
No. All right, and I just really, I'm sorry, ready to move on.
What, no, I think this is more for y'all to ask
Yeah.
a question.
Okay.
We're here as long as you.
Let's go to 820 a minute. Now, this is, just for clarity, this is contract administration. This doesn't, I don't think any of this has to do with this one, the disciplinary arbitration.
What section?
Article.
Article 18.
Oh, Article 18.
Article 20 in the first one.
I thought you said
20, I'm sorry.
Yeah.
Article 20, I missed it. Okay. So, I'm not looking at, I don't have the contract in front of me. I assume that everything in 20 is contract administration.
Contract grievances, contract
Okay,
procedures.
because some places it's kind of mixed. Okay, so what we're talking about in 20 is that, as Sarah said, perhaps sometimes we agree on something. There's no perfect contract, or we just copy it each time and sign it. So people work to get language, and it may be a written dispute. It could be any contract you sign, or what you think, well, that's not what I intended. So we have a process to resolve these type of contractual issues, and then here we have the process. And so if the parties believe that the contract is not being enforced or applied or interpreted properly, then they have a right to go through a series of steps. And those steps, if they can't get it resolved with the chief or the manager, then I'm just saying it would go to an arbitration system, and there's set of rules for the arbitration. So let's start with section 3. Can you just, the current contract, if parties miss timelines, we have said this is all run on timelines, then the procedure automatically proceeds to the first step. Now that's the current state of the contract. So tell me what the city intended by making that burden on the union.
Well, because I honestly, I think it's just like who's gonna proceed to the next step. It just automatically proceeds to the next step, but then somebody has to fill out that form to AAA to get it to whoever at AAA that's gonna then process that request. And I will tell you, I typically see in contracts that we put that burden on somebody to either, and sometimes it's the city, sometimes it's the association, but the way the current language reads, it just automatically proceeds to the next step, but somebody's gotta do it. And so if the city misses their deadline to respond, then it's considered automatically denied at that step in the process, and the association can proceed to the next step in the agreement. And then the association puts that fills out the AAA form, sends it up and we sign off on it as well, and then we send it up. It's really a matter of mechanics, not trying to do any type of gotcha anything. So
I apologize for stepping out. The heartburn that I have as somebody that works on the grievances that we file is there's lots and lots and lots and lots and lots of times where we, as an association, we try to do things the right way. We have a grievance committee that meets. We follow our own bylaws that require us to make sure that we have an attorney, that you don't have a group of 5 cops not consult an attorney and just running on emotion. We do these things, we write things up, we make sure that if we're going to file agreements that we try to be timely and notifying the chief when we send stuff over. And the inability to just tell us we deny your grievance, it's almost comical that.
So currently, it presumes that, right? So it wouldn't go to the next step if it was agreed to, and you're not saying that you're automatically, in the wrong, we win, you're not saying that in the current language. So currently, it's presumed that it's denied, it just doesn't say it. So.
I understand why it's in there, so we don't have this log jam that we've had, right? Where, and I guess I just put it out there to put it out there. Yes, we filed probably more than we've ever filed under this current contract than we've ever filed under previous contracts. But my opinion, it shouldn't be that difficult to get with law and say, hey, is this something that we believe we screwed up on? And I don't ever expect law to say, hey, we screwed it up, right? Like, I've had that back and forth over and over. But to just tell us, hey, we disagree, because we disagree on a lot of stuff. And how many times have I stepped into Scott's office and we talk about something, and it's really, really easy for Scott to tell me, Thomas, I disagree. And so it's in the spirit of, and we've negotiated something, one party, almost always the association, says we believe that there's a violation of this agreement. I just think in the spirit of working together, and I'll say to the credit of this administration, the vast majority of folks that office on the 5th floor are very easy to work with. We have very, very good working relationships with folks up there. And so it shouldn't, in my opinion, it shouldn't be that difficult to just say, hey, we disagree, let's move it forward. And then, we've tried to work things out, right? It's not like the APA has a history of not being willing and open to have conversations, but it's incredibly disrespectful to me and to our membership and to the members that are giving of their time and energy to serve on these committees to just, I don't know if they get deleted, I don't know if they get forwarded and just forgotten about, I don't know what, but it shouldn't be that difficult to just say, hey, we disagree.
And I think of the standard practice of giving a written response and possibly even reasons why the grievance is denied is going to stay. This is for those situations where it might fall through the crack, and then the next thing you know, it's like, oh gosh, we're being asked to go to arbitration. What happened? And then that's why we put the word may in, because okay, this fell through the crack. Okay, Ben's now going to talk to me. I didn't see this come through or whatever. It went in my spam. There's still that opportunity to discuss. The intent is not to take away those written communications or the ability to work them out informally, formally, whatever. It's more the mechanics of the situation, because I think there was a situation where it was automatically presumed denied, and then it just sat there going nowhere. And so it's like, who sends it up to AAA?
Well, then it's not just you, it delineates the timeline, because you have things that are set off by the step 1 ruling. So if the step 1 ruling, if there's no response, discourteous as it may be, not intentional, but if it's not done, it gives you the opportunity as well to say, here's my notice. You didn't even respond. We're calling it to go to the next step. And then you have a date certain to start your next 30 days from. And so it's not any major change. It's just kind of trying to get a clarification there, basically, moving forward.
And we'll look at that. That's not staying. I think if you look at step 3, it says grievance arbitration procedure shall be implemented by the association. So I'm not arguing about the substance. We'll look at that. So, but basically, the grievance is driven. Association believes they couldn't resolve it, then they have to notify and start the process.
And I guess we're not opposed to either party starting the process. A party will start the process, but typically,
but we're not reading against you.
Yeah, typically the association of the ones filing the grievance is not.
I think the subsidy question is in section 4. Now, the current language in the contract is actually, it's pretty close to what's in the state law for administrative arbitration hearing. And I have my counsel with me, in case I misspeak. She's actually a good person in real life. So the courts don't want to hear these administrative hearings. I mean, it says in 143 you get a trial. That ain't. It's all under the substantial evidence rule, which basically means if there's no fraud, collusion, exceeds jurisdiction, a couple other things, we're not here. You picked an arbitrator, you'll have to live with it. And there have been very few successful appeals by anybody. And if they were major issues there. But, so, the current state of the contract kind of follows what I think is the state of any administrative appeal, whether it was written or not, whether you appealed from administrative hearing to try to go to district court. That the written decision of the arbitrator may be appealed only on the grounds that the arbitrator was without jurisdiction or exceeded his jurisdiction, that the decision was procured by fraud, collusion, or other unlawful means, or that the arbitrator's decision is based the arbitration is based upon clear and manifest error of law. You know, that's pretty much any appeal. So my question would be, if that's in the contract, if no one is appealing these cases either side and are changing anything, why would the city want to come in and restate what it is unless there was some advantage to the city? Why would you want to increase your ability to appeal, which would also apply to us? Why do we all want to go to the courthouse after we pay an arbitrator to hear the case?
Well, I think, like you said, it's not necessarily common that it would happen, but I think it possibly could happen. And I believe, you all had an arbitration most recently that I think it was probably considered by both sides even. So as far as number one, right, the arbitrator exceeded their authorities created under this agreement. Honestly, I think that's more the term jurisdiction. I think jurisdiction kind of has a couple of different implications, a couple of different meanings. So we've changed that to authority. I think we're open to discussion on that, but that's generally the intent there. The jurisdiction has a couple different meanings than that. And then I think the city retains whatever jurisdictional arguments it has anyway. As for number two, there is no change there. And number three, the arbitrator's decision represents a clear and manifest error of law or fact. What we're trying to assert here really is that if there really is a manifest error of fact, that the arbitrator did not get it correct in the factual account, then that's what we're looking at.
But that'd be 100% of the cases could be appealed under that standard. The arbitrator heard the facts. They are the trier of facts. They looked at everything and made a decision. Okay, now, we may not like it when people don't get their jobs back in arbitration, or people upset when people do. But in these cases, what you really did is you expanded the definition to the point of which the city can appeal every single arbitration, arguing that, well, obviously he didn't understand the facts the way we laid them out. Well, that's not in any contract that I'm aware of. And it totally goes against what the state law puts out in 143 for scope. We don't want cases of people. We're willing to live. Had we lost and you're upset about the monitor case, so, well, what if it had gone the other way? We're upset, but I don't think we ought to be appealing because the facts were heard. And there's no error of law, no fraud, collusion, or exceeds jurisdiction. We can debate authority versus jurisdiction. So, but what you're asking for is a substantial change in this case, and that will all end up in court all the time.
And
We are asking for that. We believe it's in the best interest of all parties if there is a clear and manifest error of fact, that be.
But
That is
you're
exactly
agreeing
what we're
that that's
asking.
just going to open every
No.
case to appeal.
I'm not agreeing that every case represents a clear and manifest error of fact.
But that's an argument. The facts have been heard.
It's then a jurisdictional argument for the court. But we believe that is what we are asking. Yes.
Okay, I just
That
want
is
it clear
exactly what
that
we're
you're
asking.
opening it up so you can either side. If you don't like it, you can go to the courthouse and spend taxpayers' money tying it up for the next 10 years.
If
Or we can go and
If
tie
we
it up.
believe there's a clear and manifest error of fact on our side or on your side, we do believe
That
that's
just
the
means
best
you're
interest,
lost
yes.
and you're not happy because all of the others cover.
No, that's not what we're saying. Not that we're not happy. We're saying if there is a clear and manifest error of fact,
And
that it deserves. to be
what is the
reversed.
definition of a clear and
That
manifest
would be up
error
for the
of?
courts, that would be up for the court's jurisdiction,
And-
accepting the case or not.
yeah,
I mean, but yes, we are asking for that exactly.
We understand your
And
position.
the interpretation of facts and the arbitrator's interpretation of the facts, that's not what the appeal would be about. It would be there is a clear and manifest error of fact. Something is very wrong, that is opposite of what's in the
But that's
record.
just a retrying of the facts.
Well, we would still follow
But
the
you're just
substantial
making an
evidence rule.
argument. See, I don't care whether
You
you're,
understand what we're asking.
I understand
That's exactly
exactly
what we're.
what you're wanting.
Yeah.
And
You're misinterpreting. you're misinterpreting what we think would happen.
We think you're
But
gonna
you can
blow
have an opinion as to
millions of
what would
dollars
happen.
in taxpayers' money fighting over a contract violation that was determined by a party we both agreed to.
We understand that you believe that, we do not
I'm
believe
just
that.
saying what's gonna happen,
Well,
because nobody else has this.
We don't believe that would happen, just because
We don't
nobody
want
else has.
cases being appealed to court, we want them settled.
We hear you, but that is what we're asking.
And at least we have clarity. That's all we have.
And that's it for 20. So if there aren't any other questions.
No, that, I think we have some areas in which we can work on, I think some areas we're not going to agree to. And probably the same on your side, so.
Could I ask, on 17, on section 4, you asked us to relook at that,
Yes.
and I would ask, and we're happy to do that, and try to ensure that we didn't inadvertently, take things out that we didn't mean to, and that if we did, we make it clear that we did. And I would ask that on the 180 days, that if you don't like the language there, you would come back to us with something that would make it more comfortable, so we should be working on something.
Let me just say this.
We're not really here to negotiate against ourselves. We would
Well, I
prefer not
understand,
to.
but what you have on the table isn't what was stated as your objective. I'm asking you to rethink, does it accomplish what you said you wanted to accomplish? To me, that's that period where there's parallel cases, and you don't want the chief to have to make a decision administratively without knowledge on the side. And I think that's what Rebecca laid out. We're open to that. But going back and arguing.
Well, and I think that our language as we propose, that to us, that sets out that objective. I think what she's saying is just come back with some language. We'll look at it. We're still here at the table. We still want to talk about it. Let's see some of your language that you're thinking of so we can see it and apply it.
I don't have a problem with the current contract. You want to change it, I would ask you to clarify. You think it does what you want, I'm telling you, it doesn't. So I'm not here to figure it out for you, I don't want to change it. But if you think there's something wrong that we both agree needs to be fixed, then we'll try to fix it. What you put on the table doesn't fix it. It just gives 365 days from discovery for everything, and then just puts out some more stuff. It doesn't fix that problem.
Well, I think it does clarify that we are not attempting to override 056 through this contract by excluding it. That wasn't clear in the prior language.
But I think, mistake Rebecca, she thinks there needs to be clearer language than what's in 143.056. It needs to be.
No, actually, the current contract doesn't refer back to what I think is the practice that the city's currently does in regards to going to the AG. I think the current contract actually shortens what's in 143.056. And so this was our attempt, and you'll see that the language that we put in there actually mirrors 056H, pretty closely, because we're not trying to take away from that intent. So I think the current contract language is what we have issue with. What we're trying to do is basically mirror that, but include the 365 days. That's really the main deviation in terms of that.
So, I understand. We'll take a look at it. Really, the question is 180 days versus 365, occurrence and discovery, or just discovery?
Well, so we've asked for discovery for.
I understand.
Yeah.
I'm just saying that's really what's there. And then whether there's conflicting language in the contract, that and what the state law says in 143.056. We'll take a look at that and we'll see if we can give you some clarity.
Conflicting and or because it's not referred to less clear.
Okay, I understand. That's all we had. Unless you have any counters or other materials, we would hope next week that we would get some response from the city on financial and promotions. Or if you have other things to put on the table today, then we can break and wait for that.
We may be able to come back to you with promotions this afternoon. I think we need probably about 20 minutes to determine whether or not we're going to be able to have it for you or not today. Yeah, so I think what we should do, just because we do have a public who may or may not be interested in promotions, why don't we come back down here in about 20 minutes and re-announce whether or not we're going to be meeting again? That makes sense?
That'll work.
That way they're not just like hanging.
All right, thank you.
you or not, we're looking at the same place we were last time, the PDC room 1401. So,
They're both good locations. I mean, this worked. It's just harder on
it is harder.
public. It's hard to get parking.
This is our third choice. If the third choice, that means
The
last
EOC,
choice.
the EOC, us Energy Center.
Okay. Well, I'm gonna get with the team here on our break and see if there are any other issues we don't have on the table. I think you have everything but A16, our position, and everything else I believe we've given to you. We probably owe you some counters and we probably wanna.
Yes, yes.
Anyone
So
else
as
that-
far as initial proposals, everything I think is out there. As far as counters, we show a lot on your side, but you've already given us one proposal, so they're just counters that we're looking for counters back on. We're working on financials, we're working on promotions.
Okay.
We have a couple, what else do we
I have
have?
7 and 13 on our side.
Yeah, 7 and 13 we're working on.
The rest of the
Yeah, and there may be some, there's about 2 or 3 of which we can probably get a TA on. I just need to talk with the team, or we're really just
Okay.
inches apart. I think there's some pre-option stuff.
Okay.
I'll try to do those so we can get some things off the table and narrow it down to the big ticket items.
Sounds good.
All right.
Okay, for the public, I don't know if you heard, our next meeting is on the 30th at the Development Services Building where we were last week. It'll be posted, so.
Yeah, what time?
10 o'clock. All right, and I presume you're gonna use the room for a while?
No, yeah, the conference room, yeah. We have
No.
lunch break and I want to work with it.
Okay, yeah, okay, cool.
Well, thank you very much.
All right. Bye, guys.